about 12:15, a little bit after. This is a very dense training. It can be quite long, so I might be going fast during certain parts, but if anybody has any questions, at any time just raise your hand and I will stop and answer your question, okay? So, welcome to the restraining order training. Today I'm hoping that everybody, well, let me backtrack. When I first started researching this topic, my mind was actually blown. I realized that all of us, how we've been approaching restraining orders has actually been completely wrong. So some of the information you're going to receive today is kind of upsetting, especially if you're trying to defend a client against a restraining order. However, it's very beneficial for the clients that we have that are asking for restraining orders. Okay? So, Section 213.5 of the Welfare and Institutions Code, that's what governs the dependency courts, their ability to issue restraining orders. This code in of itself does not define or give the elements of what needs to be proven in order to issue a restraining order. Instead, it just, this part of the code just indicates exactly, or it gives the authority to the juvenile court to issue restraining orders, and it gives the authority of the courts to prevent the, to enforce an order to prevent contact from one parent against another person. Okay. Under 213.5, it actually directs us to the section 6300 of the Family Code and section 527 of the Code of Civil Procedure. Those two are two different types of restraining orders. Okay. So there's actually three types of restraining orders. There's one, that's domestic violence restraining orders, that's under 6300 of the Family Code. There's the civil harassment restraining order, which is 527 of the Code of Civil Procedure. And then there's social worker restraining orders, which I believe, that's actually in the Welfare and Institutions Code, which is a totally different type of restraining order as well. So first we're going to hit on domestic violence restraining orders. So the Domestic Violence Prevention Act was created in 1993, and it basically enables victims of domestic violence to be able to get restraining orders easily, basically. All it requires in order to get this restraining order is a showing of a past act of abuse. However, it only protects certain types of people. Okay? So, under Family Code 6203, past acts of abuse. What is abuse? All right? Abuse is defined as intentionally or recklessly causing or attempting to cause bodily injury, sexual assault, and to place a person in reasonable apprehension of imminent serious bodily injury to that person or to another. Note that it doesn't say actual apprehension of harm, but it's reasonable apprehension. And it's also to engage in behavior that has been or could be enjoined by Family Code 6320, which includes molesting, stalking, threatening, credibly impersonating, falsely impersonating, harassing, making annoying telephone calls, etc., etc. Also, disturbing the peace is also protected under 6203 in regards to marriage of non-carnal. Disturbing the peace is basically defined as conduct that destroys the mental and emotional calm of the other party. So, as you can see, that's pretty broad of what abuse could actually be. So maybe this could possibly be defined as almost like verbal abuse, or somebody coming to the house and yelling and calling somebody names. That could potentially be defined as a past act of abuse under the case of in-re marriage of non-carnal. Abuse is not limited to the actual infliction of physical injury or assault, and again can be verbal abuse. Okay. As I said before, the applicant of the restraining order does not need to show that he or she is in fear of the person to be restrained. In fact, there could be evidence presented to the court that they violated past restraining orders. That they could actually say in their affidavit that I'm not scared of this person. Doesn't matter. Just a past act of abuse. That's all that needs to be shown. They don't need to show a probability of future abuse. This could be abuse from years before. All they need to show is that there's been one past act of abuse. Again, past abuse does not have to have happened recently. In Rodriguez v. Menjivar, the appellate court reversed the lower court's decision where the lower court denied a restraining order because the applicant alleged abuse that happened 6 months prior to the request for restraining order. The court held that it doesn't matter how long ago this past act of abuse has happened, All that matters is that there is a past act of abuse. Okay? We do have a little bit of leeway for people who are trying to defend against these restraining orders. Luckily, badgering or agitating alone is not enough to prove an abuse. Okay? There's one case where a father had thrown the covers off the mother in the middle of the night and refused to leave the house, and it was a custody dispute. In that case, the father found, or the court found that that was not enough. Abuse was also not found when a person twice met the applicant in a public place and attempted to talk with her when she did not want to talk. That was not enough. Okay. One defense that we can potentially have with a family, like a DVPA restraining order, is looking at who can be protected. Okay. So although we are limited in being able to defend just by looking at the element of the restraining order, DVPA restraining orders are restricted to certain people. Okay? The only people that can actually be protected is a spouse or former spouse, a cohabitant or former cohabitant. It's basically anybody in a relationship, okay? An intimate relationship with a person with whom the respondent is having or has had a dating or engagement relationship, a person with whom the respondent has had a child with, and then the child of the party. Then the last one is any other person related by consanguinity or affinity within the second degree. So, for instance, related to the person by marriage, like a sister-in-law or brother-in-law. This would not cover, for instance, a case where the mother's roommate. Has anybody ever seen like a restraining order where somebody's putting down the mother, the children, the roommate, the grandma, great-grandma? There's only certain people that are actually protected. So that roommate wouldn't be protected. And potentially, since it says within the second degree, like a great-grandmother wouldn't be protected.
Wouldn't they qualify as a former cohabitant if it was a roommate?
It's usually, so, if they're, let's say it's a situation, if the parents live together with the great-grandparent, then yes. But if the person to be protected never lived with that great-grandparent, then no. Okay, so let's talk about children being restrained, okay? There has to be evidence indicating that the children's safety might be in jeopardy absent their inclusion in the restraining order, all right? There's two cases that are a little bit different. The court in Re CQ, the court here, they found that the children could not be a protected party when the children had witnessed father on one occasion hitting the mother on the shoulder. In this case, the father had never physically abused the children. He always walked away from the children when the children tried to intervene in fights. So it was only a one-time incident of them actually observing. However, the court held differently in the case of In Re Bruno M. Okay, but in this case, it was really extensive domestic violence. As you can see, so in this case, the father had beaten the mother 3 times a month for 10 years, and the court held that the children, although not physically harmed, were in the line of fire, basically. One child was seen to be covering her ears when her father would be beating her mother, and the other child at one point thought that his unconscious mother was dead because of the beating. So obviously these are two totally different situations. However, if you see kids that are protected on a restraining order, and the court has ordered monitored visits for your parent, and the children have never been, as in Re Bruno M is held, in the line of fire, and it hasn't been to that extent, there's definitely an argument under In Re CQ to get them removed from the restraining order, okay? Because it's only supposed to be, again, when this is the only way to keep them safe. And when we have a case in dependency court, we usually have other means to keep the children safe. All right, so the burden of proof. The burden of proof for a DVPA restraining order, first of all, for the TRO, if you're actually applying for the TRO, it has to be granted. As long as there's a past act of abuse that's alleged, it absolutely has to be granted. The court can't just say, no, I don't think that this is an issue, and deny the restraining order. A TRO must be granted if there's actually a past act of abuse alleged in the petition. But for a permanent restraining order, for a DVPA restraining order for a domestic violence situation, for the permanent, the applicant has to prove for a preponderance of the evidence. So it's a very low burden, okay? So for noticing for the TRO in itself, no notice needs to be provided. It doesn't actually specifically say that. It says that it can't be denied solely because the other party was not provided with notice, but there's nothing else that says what type of notice needs to be provided. Okay? So basically, no notice needs to be provided for temporary. All right, so now we're going to talk about civil harassment restraining orders, which are completely different. We mainly deal with DVPA restraining orders, because we mainly deal with domestic violence situations or cases that come in from domestic violence. But I think many people have had the case where a foster parent is trying to get a restraining order against your client. Or a father in one case is getting a restraining order against a father on another case. This is what these actually cover, okay? So to obtain a civil harassment restraining order, the applicant must show that he or she has suffered harassment and that the harassment will result in future harm. Okay, harassment is defined by many different things. It's either unlawful violence, a credible threat of violence, or a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person, and that serves no legitimate purpose. Okay? If this is what is being alleged, the course of conduct has to be which would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress to the petitioner. Okay? So not only just a reasonable person would suffer, they also actually have to suffer distress. All right, so let's look at unlawful violence. Unlawful violence under harassment for a CHRO is any assault or battery or stalking as prohibited by the Penal Code. Okay, but it can't include self-defense. Okay, so let's look at credible threat. That's a knowing and willful statement or course of conduct that would place a reasonable person in fear for his or her safety or the safety of his or her immediate family, and that serves no legitimate purpose. And then it further defines what a course of conduct, what a pattern of conduct is. Okay. Constitutionally protected activity is not included within the meaning of course of conduct. This is interesting, especially in dealing with our cases, okay? I think we've all had we all know about 827, right? And that's where parents and all parties are prevented from actually disclosing information. I'm gonna close the door. 827 prevents any information being disclosed about our cases to the public, right? So it's what's interesting about this is what is constitutionally protected in regards to 827. This has never been taken up in regards to dependency cases, but it's something to think about. Okay. All right, so credible threat continued. The threats should be assessed in the entire context and under all circumstances in which they are made. The person threatening does not need to intend to carry out the threat. It is only important that the person being threatened can reasonably believe they are being threatened. In this case, it's another case. There's a case that's similar to Huntington Life Sciences, and that's a case where some teenager, her boyfriend, was making threats to her parents. And he was doing it in a way to try to manipulate them into being able to see their daughter. They actually believed in the threats. They thought it was going to happen. He had no intention of carrying it out. However, the court said, well, they would reasonably believe so because you wrote these threatening letters saying that you're going to kill them. So any person would believe that that would be true. Okay, so now a knowing and willful course of conduct. So for the section for harassment for a knowing and willful course of conduct, it must be directed at a specific person, that seriously alarms, annoys, or harasses the person, that serves no legitimate purpose, and that would cause a reasonable person to suffer substantially emotional distress, and must actually cause substantially emotional distress to the petitioner. Okay. So the appellate court held, this is one good thing about restraining orders, the appellate court held that although there was a showing under this section that neighbors who played recreational basketball in a residential backyard at reasonable times of the day for less than 30 minutes at a time may have caused the applicant substantially emotional distress, it would not cause a reasonable person to suffer substantially emotional distress. So this is the one time they found that the restraining order under CHRO under this section would not apply because no one would actually be that emotionally distressed by somebody playing basketball. So, However, just like I said, letters containing death threats to the applicant and name calling, however, did meet both prongs, which makes sense. Okay, so future harm, what is future harm? It must be a threat of great or irreparable harm. So the burden of proof is different for CHRO versus the DVPA. Here, the applicant again has a burden of proof, but they have to show, they have to prove it by clear and convincing evidence. So it's a lot harder to get a CHRO. So again, pay attention to these things, specifically when you have a father against a father or a foster parent against a parent, okay? Because it's a lot harder for them to get a restraining order through this way, and this is what they would have to do, is prove all the elements under CHRO by clear and convincing evidence versus what they would have to prove through DVPA. Okay, so the notice required for the filing of an initial TRO. This is different. So we're used to, I think common practice is, oh, someone's asking for a temporary restraining order. That's it. There's no notice really required. That's kind of how we operate. We're like, oh, okay, this is just on file for a temporary restraining order. That's actually not supposed to be how it operates. A temporary restraining order, you have to provide notice. Under CHRO, you have to provide notice to the opposing party unless they satisfy two elements, okay? First, that great or irreparable injury will result to the applicant before the matter can be heard, if noticed, and that the applicant certifies that either they were not able to notice the person within a reasonable time, that the applicant in good faith attempted to but was unable to notice, or that the reason specified the applicant should not be required to inform because of such great irreparable injury. Okay, so now we're at restraining orders protecting the social worker. So all they have to show is good cause. That sucks. So juvenile court may, for good cause shown, issue a restraining order protecting a parent, or protecting a social worker from a parent, or a person. But what does good cause mean? Okay, so under WIC 340.5b, good cause is at least one threat of physical harm to the social worker or any member of the social worker's family. It has to be made by the person who is the subject of the restraining order, and that person has to have the apparent ability to carry out the threat. Okay. Actually, let me go back to this. So and I can't remember the case, and I apologize. There was one case where a social worker was requesting a restraining order. They were no longer on the case. They were the adoptions worker at one point. They had recommended termination of parental rights. Then they were removed from the case. They asked for a restraining order because that social worker was afraid of the parent. And I think the parent did make a threat at some point. The argument was, well, you're no longer on the case, so you shouldn't really, I mean, why are you in fear? It doesn't really matter, you're not on the case anymore. They still ordered that was good cause, the restraining order can still be granted. So it doesn't matter if the social worker's still on the case, if the social worker has ever been on the case, they can get a restraining order. Okay? Okay, so when can a restraining order be filed? It can be filed any time after the 300 petition is filed until the petition is dismissed or dependency is terminated. Okay. Despite what many of the clerks say, a restraining order can be made orally, and what I mean by that is, you know how we have the applications, we have to fill out an application in order to get a restraining order, and it's supposed to be attached to the temporary restraining order. You actually don't need that to be attached, you could just orally request one. Likewise, the judge can order a temporary restraining order without anybody else requesting a restraining order. Okay. Oh, that's what I said right there. It also can be by written application, which would be that JV 245. Okay. So notice required for the temporary restraining order. Just like I said previously, just to show you side by side, DVPA, no notice. It's basically under the CHRO and the CSW, TRO against the CSW, you basically, if you're not going to give notice, you have to show good reason why not. And you have to follow those two elements. Okay. So this is where it's going to get a little bit different. Traditionally, when you're noticing for a permanent restraining order, the respondent has to be personally served with a TRO, and that's under WIC 213.5 D2. However, it's recently changed, okay? Under CHRO, and actually I would argue TROs for CSWs, personal service is required. However, the DVPA has recently been changed. Has anybody heard about the changes with the family law restraining orders? Yeah, so basically at this point, if you're trying to get a permanent restraining order against a parent, you don't have to provide personal service if you're able to prove the following elements: that the petitioner has made diligent efforts to serve, and there is a reason to believe that the respondent is evading. Okay, that second part is very important. We have a lot of cases where we can't find the parent, where we're like, I'm trying to file this restraining order. I'm trying to get a permanent restraining order for my client. However, this guy's in the wind. We don't know where he's at. That's actually not enough. We would actually have to show that this person is actively evading. Okay, so beware of that. It could be where you'll see in the reports there might be some mention of that, or talk to your client. So if you're able to prove that the petitioner has made diligent efforts to serve, and that there is a reason to believe that the respondent is evading, then the court can order that you send notice by first-class mail at the last known address or by publication. Talk to your firm about what we need to do regarding publication and what we need to do, the efforts we need to make prior to actually doing the publication. Okay?
One thing just to mention here, this is still a work in progress. We're sort of cobbling together a way to effectuate publication. And unfortunately, the Judicial Council seems to have come up with a form to be used in the family court, but we don't have one yet that's a juvenile. So it's still a work in progress. So before you run in there guns blazing to get your publication order, make sure you're conferring with the supervisor from your office.
Yeah, and just certain things to point out too. How do we make diligent efforts, right? You should be talking to your investigators to assist in serving, but when you're talking to your client who's protected by the restraining order, ask questions like, where does this guy work, or where does this woman work? Where do they hang out? Are they visiting? Ask questions so we can get a lead of exactly where they're at, where these parties are going to be. Okay. I think traditionally we would just say, oh well, we just don't know where they're at. But now we should ask those follow-up questions.
I thought we could also, and I could be wrong about this, but I thought you could also state them not just at the last known residential address, but also if you have a work address.
That's not what the code says. It just says last known address.
Where I saw that.
Something else that we could do as well is ask that, because we do serve through CalServe, we can ask CalServe to do what's called a skip trace, but talk to your firm director to determine if that's something that's available. A skip trace is like a due diligence that they do. Okay, so the continuance of a restraining order. The respondent is entitled to one continuance for a reasonable period of time to respond to the petition. Okay, I'm going to be honest, that doesn't mean that that's it, because we could always fall back on WIC 352 to ask for more continuances if need be. But technically, under WIC 213.5C2, the respondent is entitled to only one continuance. The court may also continue a restraining order upon a request by the petitioner if there's good cause. And then if the court grants a continuance, of course all the orders in the temporary order will remain in full force and effect. Okay. But at the same time, they also may modify or terminate the temporary restraining order as well. Okay. So the orders enjoined actions, I mean, we all know this, molesting doesn't actually have to be technically molesting. So molesting is like harassment, okay? Attacking, striking, stalking, threatening, sexually assaulting, battering, harassing, telephoning, including but not limited to, making annoying telephone calls as described in section 653 of the Penal Code, destroying the personal property, contacting either directly or indirectly by mail or otherwise, and coming within the specified distance of or disturbing the peace of the child or any other child in the household. Okay. The court also may exclude any person from the dwelling of the person who has custody and control of the child. But there are restrictions to that. That's not a blanket thing, okay? In order to be excluded from the household, the court or the petitioner must prove that there's facts sufficient for the court to ascertain that the party who will stay in the dwelling actually has right to the dwelling. So it can't just be someone who's just living there. Is their name on the lease? Whose name is on the lease? Look at utility bills and so forth, okay? There also needs to be facts showing that the party to be excluded has assaulted or threatened to assault the other party. So it's just same as what's under the elements for restraining order. And finally, it must be showing that physical or emotional harm would otherwise result to the party if the exclusion order wasn't actually granted. So I think most important for us would be showing whether they have the right to stay in the dwelling or not. Okay, so duration of orders. The TROs, if the temporary restraining order is granted without notice, the permanent restraining order hearing must be set no later than 21 days, or if good cause, 25 days. Okay? Many times we waive this period of time, but just remember, if you have, if you have a parent who's present and the respondent is present, yes, if they're okay with waiving time, you may. But if your person that you're representing is not present and they want you to agree to extend it, you don't have direction. So by law, unless you actually try to extend it, by law, the permanent restraining order has to be set for 21 days or up to 25 days. Okay? For a reissuance, it's basically the reissuance of a restraining order can be in effect until the date is set for the hearing. All right. And then order after hearing. I think we've had a problem with this before, but I'm not sure if it's still a problem now. In the past, certain bench officers would try to set restraining orders that lasted forever, like 5 years, 7 years. Under 213.5, it indicates you can't issue a restraining order for no more than 3 years. Okay. So the violation of a restraining order. If you violate a DVPA or a CHRO restraining order, you're basically convicted of misdemeanor. Okay, it's punishable by a fine of not more than $1,000 or by imprisonment in county jail. But for violation of a restraining order protecting a social worker, it's contempt. Okay, so there should be some type of contempt hearing. Okay, so I provided everybody with a restraining order cheat sheet, and it's because it's very dense information. There's a lot of information. So this kind of breaks it down for you, okay? So as you can see, DVPA, elements, acts of past abuse, CHRO, harassment and future irreparable harm, and then CSWRO is good cause, okay? And then it goes down and it compares the burden of proof. Again, the only burden of proof that's, the heightened burden of proof that's necessary is for a CHRO, which is clear and convincing evidence.
Someone's parked in a reserve parking.
Oh. So, yeah, so the only heightened burden of proof is really for actually it's for CHRO, I'm sorry, and CSW restraining orders, all right? Domestic violence restraining orders, again, it's just preponderance. For who can be restrained, the only restriction is on DVPA. Again, make sure you're really looking at the person that's being protected and determine what standard you need to be used. Again, if it's a friend who's living in the home, it's not necessarily a person who can be restrained under a DVPA, but it can be under a CHRO, which requires a heightened standard of proof. For DVPA, again, notice is not required for your TRO, but with CHRO, CSWRO, it is. And then there's also the notice requirements that are different for the permanent order. And then finally, a violation for DVPA and a CHRO is a misdemeanor, whereas CSWRO is contempt. All right, so I made a sample restraining order, and I made mistakes. I was trying to make it very realistic. So when we do restraining orders. So I apologize for that.
And I'm just going to weigh in here because I sometimes get provided with a list of rejected restraining orders and the reasons why, and I can tell you that it's really like petty, minuscule little mistakes. So for instance, looking at this, if you looked at on the JD 250, at the top where it says notice of hearing and then there's a box that's empty, that would have to be checked or it would be rejected. Or on number 4 on that same document, Christina filled in all of the information about the actual hearing but did not check the box on number 4. that would be a reason for it to get rejected. So you have to be really, really careful about proofreading these before you turn them in, because otherwise they're just going to throw them right back at you a few weeks later with disdain from your court clerk.
And if you're in Department 404, just defer to Donna. So I'm not sure if this is correct to Donna standards, but okay. So when you're doing a temporary restraining order, first of all, well, I'll get to that. Okay, so when doing a temporary restraining order, usually you have the request, you have the actual order, and then you have the CLETS form. If a child is protected, that a parent who's being who's being restrained has a right to visit, you should also attach a 205. Okay. One thing to note about the CLETS form: you're not supposed to attach it to the restraining order. So although it's attached here, it's not supposed to actually be attached to the restraining order. It needs to be a free leaf copy, because it's confidential, and it's for, I believe it's for the sheriffs to actually have, so they have that information regarding the person to be protected and the person to be restrained. Okay, so it should not be attached to the actual order itself, or the applicant. So it's pretty self-explanatory. In this case, I used Harry Potter. I liked Harry Potter, so I used him, being protected from Voldemort. And then I marked, so as you can see, it's pretty self-explanatory. Trying to see what I want to specifically talk about. So if you see on part 6 on page 2, all you really need to indicate is, again, description of conduct. You would have to describe conduct that would be sufficient under what type of restraining order you're actually requesting. Okay? So although we use this form for all 3 different types of restraining order, just make sure when you're describing the conduct, you have to actually think about what you're actually doing. In this case, Harry Potter is not in a relation with Voldemort, has no real relation with Voldemort, so it would not be a DVPA, it would be a CHRO, right? So I would have to put in facts that would be, that would meet harassment under the rules of CHRO.
And also sometimes people will just say, see report or see, that is not sufficient. You can't just attach the social worker's report or attach something. You have to actually write it onto that document, or else it'll get rejected. They get separated, and then the sheriff just sends it back.
Yeah.
So whether we're operating on the theory of CHRO or DVPA, the document is still the same, right?
Still the same.
Okay.
Yeah.
So Christina, just if we are defending a restraining order and we are trying to figure out, okay, am I operating on the DV set of rules, or am I operating on the civil harassment? Do you have any suggestions for how we should do that?
So the first thing I would look at is who's being protected from who. So first I would see, is this like an intimate relationship, or is either person related to each other through an intimate sexual relationship or loving relationship, okay? If that's not there, then you're going to be going under the CHRO rules, okay? So again, here's another example. Let's say mom's in a relationship with a new guy, dad number 2. She asks for a restraining order against dad number 1, protecting her and dad number 2. For her, she could be protected under DVPA. For him, he would be protected under CHRO. So there's 2 separate standards that you're actually using, okay? So you just have to look, and you have to look at specifically every single person that's being listed. So that's the first thing that you would look at. Actually, I think that's, yeah, that's the thing that tells you what standard you're going to be using, is who's protected, okay?
Christina,
Mm-hmm.
so looking at number 3 on the first page, would we check B if we were filing at the detention because the child is not yet a dependent?
Yes.
Okay.
So if you're at the detention, this is when we have to do a lot of restraining orders, and they're just subject of a petition, then you would mark B. You don't mark A, which is a dependent of the court, until after disposition. Okay. We would never mark C or D because we don't work in juvenile delinquency. Okay. I'm sorry, C, D, E, or F. All right. Okay. So on number 8, just to shoot forward to number 8, this kind of talks about visitation. Again, you would only mark that the person may have contact with visitation if you're protecting, if the children are actually protected on the restraining order, and if that other person has the right to visits. Okay. 8C, that's the move-out order that we just talked about. Okay. And then all of D talks about the areas that need to be protected. This is new, the possession and protection of animals. We've never, I mean, this has happened in the past couple of years or so. I've never had this come up where a client has needed their animal to be protected, but maybe because I've never really asked. But yeah, so that's a new thing. Okay, so I want to get to the order. There's one part in particular that the clerks really get upset about. Okay. Actually, before I get there, on number 4, the actual order itself, 4C, persons and attorneys present. The only thing that the court really cares about is the parents, the people that are to be protected, and the attorneys that are there. So you don't need to list county counsel. You don't need to list CLC attorneys if the kids aren't protected. You just need to list the attorneys for the parents, if it's going to be a mom against dad, the attorneys for those parents, and the actual parents if they're present or not. Okay. And then on page 3 or 4, number 14, I'm sorry, number 13, the clerks really prefer us to always check mark box B of 13, never check box A because it requires them to do more work, and they hate that. So, okay. So I said earlier about under DVPA, the notice requirements are a little bit different. If a parent, let's say you're trying to restrain father from mother, and their whereabouts are unknown, and we need to kind of do our due diligence to see if we can find that parent to be able to serve him, getting the information on the CLETs is actually helpful to us because it asks for a lot of information here. It asks for the address where the restrained person lives, the type of car, the work address, and so forth. So actually spend time. I know some people will just write in the information they have and not even ask questions of the client, but really spend time with the client over this to see if you can get more information regarding the person to be restrained. Okay. So, and again, 205 would have to be attached if you're having any children that are going to be protected. As to, for getting an extension, let's say you're not able to serve the party, then you would file a request in order to continue a hearing. This form has to have the actual temporary order attached to it. Okay, you can't file this free form. You have to have the temporary attached to it. And although technically it's not supposed to be good cause to continue restraining order if everybody agrees on continuing it, that's kind of how we do it. It's usually okay. If everybody agrees on continuing the restraining order for a specified period of time, you can. Okay? Okay, so there's that one. And then finally, there's the permanent order, which is exactly like the temporary order, has the same information. You don't need to personally serve the permanent order on the party if the person was present if the person was personally served for the permanent order, okay? So if the person was personally served, all you have to do is send by first-class mail to their address with a copy of the restraining order, as long as it doesn't have new information, okay? So if you change it and you're now protecting another party, or you're asking for them to stay away from a kid's school and if that wasn't requested before, then yes, you actually have to personally serve them with a permanent restraining order. Otherwise you don't. Okay. And that's actually it. That was way quicker than I thought it was going to be.
I have a question.
Yeah. Mm-hmm.
So when there's a restraining order that's out of our jurisdiction, for example, so if there's a criminal restraining order, we know we can't modify it, but we can, under the local rule, ask the clerk to contact the counterpart.
Yes.
For example, a family law order, so if it's a TRO, we know that we can actually have the actual restraining order heard in dependency court.
Yeah.
But what if it's an actual restraining order? Do we have any jurisdiction to modify the restraining order? Do we have to refer them back to the family law court? And then the most pressing question, which I see all the time, is what if there's a dependency restraining order that's granted here, but jurisdiction closes? What happens to that restraining order? How do you modify that?
Yeah. So I actually don't have the answer to the second question, so I'm not sure. As to the first, I believe that's also under WIT 213.5. I'll email everybody about this to actually really be specific, but you can modify. You have to provide a certain type of notice. It would be the same exact notice that you would as if you're asking for a permanent restraining order, but you can actually modify that order.
Here,
Yeah,
dependency?
here, because we have exclusive jurisdiction.
For a family law court or dependency?
So if there's a family law restraining order and we need to modify that
Got
here,
it,
we
got it,
can.
got it.
But again, depending. I mean, if it's like mom against some random boyfriend she doesn't have a kid with, I would probably say no. But if it's like, yeah, mom and dad in this case, then yes.
Got it.
But let me look into the exact code to actually be more clear. Yeah.
Thank you.
So, yeah.
Well, that was my thought too, is I've been seeing the court assume jurisdiction of restraining orders against people who aren't parties. Is that
That can happen.
allowed? Or
Under
not?
213.5, the
Even
court.
if the children aren't protected?
Yep,
Okay.
the court has exclusive jurisdiction.
Okay.
That being said, if it's like, I don't know, like something that's so unrelated to the care and custody of the children, then I would argue that they shouldn't be able to, because this court is only supposed to have exclusive jurisdiction over the matters of dependency. So if it's something so ridiculous, no.
And be careful about the court trying to appoint you to represent one of those randos,
Yeah.
because that
Yeah.
happens where the dude shows up and he's like, I need representation for the restraining order. We do not pick those people up, so they're on their own. The court can,
Yeah.
give them time to hire private counsel or let them go in pro per, but be careful about that, because the court always wants people represented and they don't like hearing the oath from us, but that's not appropriate unless they're a parent.
And it's awkward and it kind of sucks because, I mean, especially knowing how easy it is for a person to get a restraining order under DVPA, we're going to run into this more often, this problem. I have a case right now where the person that abused this kid, she was living in the same home, so same type of thing, they were living in the same home. This guy abused this kid, sexually abused the kid, and threatened to kill her. So, but he's not related to the child at all. So there's a restraining order that was filed, but now he's going to be brought in from custody, and this is just going to be really awkward. I mean, what do you do? He doesn't have the right to an attorney. It's uncomfortable. But unfortunately, that's just how it goes. So, yeah. Any more questions? Yeah?
In those circumstances, one thing, by the way, is a lot of times the criminal court will have issued restraining orders, and your client won't know about it, they didn't, but if you reach out to if you have the victim and you reach out to the DA, you might be able to get a copy of it, because oftentimes they'll issue 10-year restraining orders, those trump any family law or juvenile restraining orders in any case, so it can save you a lot of time and trouble sometimes if you just reach out to the prosecutor to see if you can get a copy.
Yeah.
Can you talk a little bit about advising our clients who maybe go out and get a restraining order in family court when there's an open dependency court case? Can you talk a little bit about that situation?
Yes. I mean, I think at detention, we should all be mindful about talking to our clients about our court having exclusive jurisdiction. Of course not in those terms, because they're not going to know what you mean. But as we all know, we have many cases where somebody just filed a case in family law court, or they're going to now be seeking custody. So it's very important to make sure you talk to your clients that this court has exclusive jurisdiction over not just the custody of the children, but anything regarding the children. All right, absent child support, of course. So it'd be really, it's important for you to talk to them about that. Is that what you're kind of saying? Okay. So.
And the family court's not supposed to issue those when they know that there's a dependency case open. It's shocking how often they do. But generally, if your client comes to court, you're at the 2-1-E, they're waiving this TRO in your face they just got from family court on the custody dispute. Usually what will happen is the court alert your court, the clerk will contact family court, they'll set a hearing in dependency, but they're not supposed to do it like that.
And
they don't know that.
And you should notify, if you know that your client filed a restraining order in family court, it's best to notify your court and let them know and give them the case number and calendar it. Because I think the worst thing is you walk in, you see this what is it called? The add-on calendar, and you're like, what is this OSC on for? Interesting. And it's a restraining order for your case that you haven't typed up. That sucks. So just make sure that you notify the court when you have
And it
information.
needs to be put on dependency paperwork, the JV forms. So you can't the court can't actually, most clerks will tell you that you have to prepare the actual temporary order on the JV paperwork in order for the court to order the permanent JV restraining order. Some fudge it a little bit and we'll just let you use that temporary until it expires and then do the JV 255 permanent order?
Yeah, 255, I think.
But it's cleaner, so if your client shows up and she's got, it's the detention and she's got, they told her to go get the restraining order, so she's got it. And it has a date set in family court, which is now gonna be advanced and vacated and calendared in our court. It's cleaner for you just to do the paperwork on the JV, 250, so the court can go off of the JV paperwork. And most clerks will ask you to do that.
And also, just important to note, is there's a notice issue there too. So if a parent, let's say, got a temporary restraining order in a family law court against another parent, and then noticed that parent was noticed to go to the other court. They weren't noticed to go to our court. So notice is not proper. So that's actually even more reason why we have to do it all over again on the 245, 254.
So if we have a case, I know family law court shouldn't be issuing restraining orders while our cases are open, but if they do, are they valid orders? Like, I have a client who between the adjudication and the 2NE came back with a new restraining order after our court denied her restraining order.
Oh,
That's
that's
arguably, I'd
interesting.
say no.
Yeah, I would say
because
no, but
because they don't have jurisdiction to do it. But
yeah, that's
not
interesting.
bad.
I wonder if the client should file some type of an appeal or something, because that's interesting.
So, but she has a restraining order, so
Yeah.
Well, I mean, I think if she's got the paperwork, unless if the father
Yeah.
takes it up.
I know.
The kids are not on it,
Yeah.
technically.
Yeah,
it
it's
should go.
probably fine.
Well,
Okay.
yeah, but technically under 213.5, we should have exclusive jurisdiction.
Well,
So
what if the kids are not on it and it doesn't affect the kids?
still, I mean, it would be arguable if it's mom and some boyfriend who has nothing to do with the kids, but if it's like the parents and they have a dependency proceeding, then yeah. Yeah. Any other questions? All right. Bye. Wait, it's so dry. God, it's so dry. Alright, I'm going to go get my phone.
Open court.
Yeah, I need to file something. Can you want to take me so I can show you about filing?
Yes.
How did Gormandez go?
Smile.
Get ready.
Sarah, I'm gonna come back. Sarah, I'm gonna come back. Thank you, baby. Sorry. I was just
It's yours, you should know, right? It's like in my purse, I'm like, what is in here? That like, yeah, like it happens.
In between when I sat down and when I
Something like crawled in there.
Something
like
crawled in there.
something.
There's more opportunities here.